Good evening. We're going to go ahead and get started, please. If everybody would feel free to sign up for both the ordinance and the resolution, and we'll go ahead and get started. Madam Clerk, if you would call the meeting to order, it is now 6:30. Attorney Rodriguez. Public comment, separate ordinance, separate resolution, correct? Madam Clerk, if you call the order.
Mayor Turpin.
Here.
Vice Mayor Dan Samaria.
Yeah.
Commissioner Johnson Sadella. Commissioner Tudor.
Here.
Good evening. After the pledge, if everybody would please stand, we're going to have a moment of silence for Elijah Cummings. Thank you.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Congressman Elijah Cummings died at the age of 68. He was a veteran congressman serving his country and representing the 7th District for the Baltimore, Maryland area since 1996. He served as chairman for the House Committee on Oversight and Government Reform, chair of the Black Caucus, championed civil rights, health care, immigration issues, and so much more. We honor his service to his country and offer our deepest sympathies to his family. Please join me in a moment of silence. Thank you. Attorney Rodriguez, if you could read the decorum rules, please.
All comments must be addressed to the Commission as a body and not to individuals. Any person making impertinent or slanderous remarks or who becomes boisterous while addressing the Commission shall be barred from further audience before the Commission by the presiding officer, unless permission to continue or again address the Commission is granted by the majority vote of the Commission members present. No clapping, applauding, heckling, or verbal outbursts in support or in opposition to a speaker or his or her remarks shall be permitted. No signs or placards shall be allowed in the Commission chambers. Please mute or turn off your cell phone or pager at the start of the meeting. Failure to do so may result in being barred from the meeting. Persons exiting the chamber shall do so quietly.
Thank you. This evening we're going to be hearing this is a special commission meeting, so we're only hearing 2 items. The first is the ordinance 2019-05, which is the first reading, which I'll do in a second, and the second is a resolution regarding the special election. Because we are doing a first read of an ordinance, we will have public comments separate for both those items. The first will be the ordinance. If you have not signed up and would like to do so, please go ahead and do so now. And after that, we'll be opening a regular public comments meeting. So we're going to start with the ordinance first, and then general public comments. Okay, so if you care to speak on the ordinance, could you call up the first person who would like to do that?
Janie Anderson.
This is the public hearing. We're opening up the public hearing now for ordinance 2019-05. Attorney, if you go ahead and read that while they're calling up the first person, please. Thank you.
I'll read the ordinance. Ordinance number 2019-05, an ordinance of the Village Commission of the Village of Biscayne Park, Florida, amending chapters 14 and 15 of the Land Development Code of the Village of Biscayne Park, authorizing special magistrate positions for certain code enforcement proceedings, providing for ordinances in conflict, repealer, codification, severability, and ineffective.
Thank you. We'll go ahead and open up the comments, and then I'll turn it over to Manager Manners. First person to speak on the ordinance?
Janie Anderson.
Chapter 162.5, it reads, the local governing body attorney shall either be counsel to an enforcement board or shall represent the municipality or county by presenting cases before the enforcement board, but in no case shall the local governing body attorney serve in both capacities. That appears to define the role of village attorney. I couldn't find anywhere where it said an attorney must attend every single meeting. Now, considering our prior to the prior attorney had 20 years with us and a long-term municipal attorney, I think he would have caught that. So if there is somewhere in that statute I missed that says council must attend every meeting, and hence why you're budgeting $5,000 for that, please enlighten me, because I couldn't find it. The other thing that comes to mind, it appears you're only budgeting for 2-hour meetings. By the time you hire this magistrate, there will have been 6 months with no meeting. Now, back in July, our meeting that never happened, we had a case that was over 500 days old. It's now 2 years old. We were so far behind because either meetings would get canceled, over 25% of them did, or we'd have such anemic agendas, 6, maybe 8 cases. You guys need to get a handle on how many outstanding cases there are before you figure that it's only going to take 2 hours. If it's supposed to be more efficient, again, like I said last time, efficiency starts in the office, and until that gets under control, 2 hours is not going to cut it.
Thank you. Next.
Rox Ross.
Please don't forget to state your name and address. Thank you.
Okay. Oh, that's it. Jamie, I can't believe you're that much taller than I am. Okay, thanks. Thank you. Rox Ross, 11166 Griffin Boulevard. Judging by the people present on the dais this evening, you're going to pass an ordinance this evening, or you intend to pass an ordinance this evening to change an 80-year village policy based on the vote of 3 elected people. Think about that. You have yet to specify what issues arose from Code Compliance Board proceedings to support this alternate special magistrate process. I only know of one case late last year where a fine was reimbursed, and having reviewed those records through a public records request, it appears that the errors of that case originated with miscalculation or collection of the permitting fees, with vague charging documents, and gaps in the presentation of the case. So, do you propose to fix those issues? Because they're all outside of what your discussion is tonight. Think about it. The Florida Bar offers some insight and best practices concerning traditional volunteer boards and alternatively magistrates for code enforcement. It's important to note that Florida Statute 162 empowers municipalities to enforce their codes, and here, like many cities, the Commission delegated that authority to the Code Compliance Board. Section 14.13 composition describes a 5-member board appointed by 4/5 supermajority in light of the current circumstances where the Commission itself is comprised of only 4 people. You should consider reducing that supermajority to a simple majority, or for each commissioner to select their member to the board. And if applying the same level of integrity to the alternate venue for the magistrate, you should consider reserving that authority to appoint the magistrate to yourselves rather than abdicating it to the manager, as the way the ordinance is drafted right now. A quick survey of Florida cities this afternoon informed me that most magistrates are appointed by their city council, or at a minimum ratified by the city council. Section 14.1.4, jurisdiction. It basically assigns all of the cases, assigns to the special magistrate all code cases where fines or fees may be assessed, leaving 0 cases within the board's jurisdiction, even if you were to make those board appointments at any time. It's a farce to say that you're setting up a dual process. Just be straight about your intentions, that you're eliminating the board. But if you do continue to actually have a dual process, then Section 14.1.7a, line 3, should say neither the special magistrate nor any member of the Code Compliance Board shall have the power to initiate. And Section 14.1.18 on conducting a hearing, it introduces a new term, a code inspector, that's not defined and we've never used in our code before. Subparagraph B introduces that cases shall be presented by the governing body attorney or member of staff,
please. Thank you.
which adds cost to your process Never in our history have we had cases presented to the board by a village attorney. The village attorney served as the board's attorney when it was needed in complex cases, so you should carefully review those sections I described.
Thank you. Next.
Chuck Ross.
Chuck Ross, 11166 Griffin Boulevard. Echo many of the things that Rox just said. I give this special magistrate issue a lot of consideration, and in looking it over, the first thing that really concerned me was the disrespect given to the code board that resigned, not even consulting them or explaining to them that you intended to do this, and they clearly this, you're just trying to disguise with an option for a code board. The intention is to kill the code board, which has already been done. So congratulations, you finally accomplished something. There are valid reasons to have a board that is a jury of your peers. Residents who have intimate knowledge of the neighborhood versus a magistrate that doesn't. And it doesn't solve the problem that appears to be the administration, as Rox just referred to. Vague comments were made to justify this change by the attorney, the mayor, and Christian, the manager. Criticizing the board without specifics. The very things that you accused me of doing, which wasn't true, you did, and you did, and you did. Christian further indicated that a special magistrate can handle matters more efficiently in his experience. Maybe he can share that experience with us in a little more detail. Finally, the change to a special magistrate is going to cost the village, if I understand the memo correctly, a minimum of $11,000? Is that correct? Plus, the attorneys being assigned the chore, the task, the extra benefit, whatever you want to call it, to prosecute the cases, apparently in lieu of the code enforcement officer that used to do it, which makes me wonder, does that mean you don't have confidence in your code enforcement officer enough to prosecute the cases? Is that admitting that the problem's with the administration, not the board? Thank you.
Thank you. Next. Caller.
There's no one else.
Nobody else? Okay, just a moment. I'll let everybody speak, but I ask everybody to just come sign up if you haven't signed up and would like to speak, and we're happy to have you talk.
Dan Keith.
If you'll just wait.
Dan.
Okay, if you just please quietly sign up for.
Okay.
There's two conversations. One is on the hearing, which we're having now, and the second is on resolution.
Right.
Mr. Kennedy, if you would please hurry up, please. Mr. Kennedy, I'm asking respectfully just to sign your name if you'd like to speak and then sit down. Thank you. Mr. Keys, since I cannot see you, I'm just going to wait till they speak, and then you'll be able to begin.
Okay.
Thank you. You may begin, Mr. Keys.
Dan Keys, 1107 118th Street. It is obvious that the intent of this ordinance is to nullify the board process. Basically, you put everything in the category of magistrate, and you said, if there's anything left, but, I mean, if there's anything that comes to mind, put it down there. And the discussion here, directing the attorney, was to split the responsibilities between the board and the magistrate, and I don't think that's what's been done. Frankly, didn't have an opportunity to tell you that because I wasn't allowed to speak after open mic, but I think splitting it is ridiculous. If you're going to do, and you want a magistrate, and you're hard pressed to have a magistrate, then have a magistrate process and have a board process with both having the same responsibility. And if you don't constitute a board, because that's what you want to do at any given time, any commission wants to do at any given time, then so be it. But you have both processes have the same responsibility. In any event, if a magistrate is appointed, is created, I believe that absolutely the commission needs to, at the very least, ratify that, if not select the person themselves. I sent you all the Coral Gables ordinance. They require ratification by the commission of the manager's selection. They also have more than one. They provide for an option of having more than one magistrate to be chosen from. If you do end up with a board and a magistrate, you ought to give the resident the opportunity to pick between the magistrate and the board process. I do believe we have responsible residents in this community that we can constitute a code board with appointments. I think it ought to be appointed, each member ought to be appointed by each individual commissioner, not as a whole. It's the way that the constituents of any given commissioner are represented on the code board. I think we had a perfectly good board. I think we need much more professional process in presenting cases to the board and more consistent process. There was a section I mentioned earlier regarding the who can mitigate fines, and we corrected the first paragraph, but then based on the way that we're presenting the situation now, we didn't. The second paragraph in that section is contrary to the first paragraph. Still would like to know what costs are that can be recovered by the village. Our the village attorney's costs involved in that. Thank you.
Thank you, sir. Madam Clerk.
Barbecue.
Barbara Kuehl, thank you, 777 Northeast 111th Street. I didn't really prepare anything because I'm just so disgusted really with this whole process. The fact that there are only 3 commissioners here, as Mayor Ross and Code Chuck mentioned, I really agree with everything they said. They brought out very important points, and the fact that there isn't even anybody else here from the community that wasn't involved with that board should tell you something. This commission has absolutely turned off the community. You'd like to think it's people criticizing, but I read the resignation letters of all of the members of the code board, and they didn't resign because you were going, it was clear you were going with a magistrate. If you did bother to read them, which I don't even know if you did, maybe when you see the names you just delete it, but there was an overriding sense of frustration with incompetent help, the code officer, incompetent supervision by the manager, and absolutely deaf ears from the commission. When the code board has written to you, I know the code chair wrote to you about different problems, it went completely unanswered. So your solution, which has probably been on your agenda before you were elected, is let's get rid of the code board, which really makes a lot of sense and really does such a disservice to this neighborhood. I didn't read it, actually. I don't even care what you have to say. Probably the code officer will be gunning for us since we've said such lovely things about her. I haven't had a code violation in the 43 years I've lived here, so I really don't expect to get them now. But if I do, there may be problems, because it seems like she did target residents who complained about her, which is another thing that this commission, deaf, dumb, and blind, not interested at all in the process. Let's now get a magistrate. And the figures for the magistrate, I pointed out the other day, were ridiculous. $6,000, 2 hours. They all said they charge for travel, going and coming, and for paperwork. That's 2 hours right there, let alone catching up on the hundreds of cases that have been swirling in outer space here. So, you know how to spend money. Now you want to get set up a board with I don't even know who you would get to fill this and what they would do. But it just amazes me how this commission, between the phones, the magistrate, now the attorney, the SUV, I mean, you just keep piling it on, and you're probably up to $100,000 with the over expenses. You really all should be ashamed of yourselves.
Thank you. Next on the list.
McDonald Cannon.
Kind of an easy name. There we go. McDonald Kennedy, 11705 Northeast 11th Place. So I did prepare a couple of things I wanted to say, but I want to respond to some things as well. Rox pointed out that 3 people are here tonight making this decision. That's a really solid point, I have to say. 3 of you making a decision that affects people's finances. 3,000 people, 1,100 homes, whatever the numbers are these days. That's really lopsided. That's really lopsided. You had one person bail on you, another one doesn't show up anymore. Did she bail? Maybe you just didn't tell us yet, I don't know. But now 3 of you are making decisions like this. A question for Rebecca: why are Rox and Dan editing the work that you charge the village for? It seems to me they're in there, correcting things and making sure things align, and it seems strange that you have residents sort of checking your work for you. So here are my overriding thoughts. You're pretending to solve a problem that you've never fully disclosed publicly and that quite frankly don't exist. We all know they don't. And now you're convoluting things beyond any reasonable reaction to your perceived problems. You, and I mean all of you, specifically Rebecca, speak obliquely about cases you've had to settle, but you haven't shown any evidence to that, and tonight Rox shows us evidence to the contrary. As a resident, I have serious issues with the code officer, which you refuse to acknowledge, let alone address. If you're claiming to respond to real challenges with code enforcement in this village, correct the code officer problem instead of pretending to address issues with the board that no one had legitimate problems with. Additionally, 5 unpaid board members are less likely to be biased. When the code officer, Christina Caserta in this case, abuses her powers and targets and attacks a resident and sends those attacks to the board, 5 people are there to protect the resident. Think about that. 5 people are there to protect the resident from the code officer of this village. She drives around wearing a badge. I need protected from her, and the board did that. 5 people protected me from her. When you send it to one magistrate who's paid and has a reason to support the code officer, i.e. a paycheck, the system is rife for abuses of power and corruption that impact residents. Residents are at serious risk with an abusive code officer and one paid magistrate. You should be protecting residents rather than the code officer. Stop convoluting the issue with a magistrate and a board. Swallow your pride tonight and humbly ask your board to retract their resignations and direct your manager to do his job. Get cases before the board in a timely manner. That's the only real issue we have with code compliance. It's you, Christian, and Christina.
Madam Clerk, next person.
Bob Anderson.
Bob Anderson, 11th Place, 119th Street. Going back when code was really first started here in Biscayne Park, all the way up until what you guys are trying to do, it's been an unpaid position. Now you want to go ahead and start charging the residents at least $11,000 a year for this. You say it's going to be more efficient. You know, it's really very interesting. One of our commissioners brought up about a whistleblower project to go ahead and protect our employees if they see something wrong. You guys listened to that presentation and decided the cost of the ordinance costs too much money, but you do have the money for this. So I wonder where the priorities are. And I also I'm starting to hear from a number of people, what dirty little secret are you guys trying to hide?
Next.
Fred Jonas?
Fred Jonas, 918 119th Street. I want to sort of restate and refocus what Roxy Ross said and Barbara Kuehl and Matt Kennedy. And I want to put it to you in a slightly different way. We have a crisis of government right now in Biscayne Park. We have a very small commission. It's a small neighborhood, so it's a small commission, 5 people. One of them has quit. Another one reportedly has asked to quit. But has stopped showing up. And the whole commission is under investigation by the County Ethics Committee. This is not a good time to be manipulating boards and coming up with new ordinances like this. Not to mention that not only was the Code Compliance Board never a problem, but the problem is the thing we're not changing, which is the Code Compliance Officer. That is an obvious problem. Everybody's talked about it. Meetings are disorganized or they are canceled because of the Code Compliance Officer. That stays the same if we have a magistrate. So I agree with Mac. I think what you ought to do is realize that you have placed yourselves in a very bad position. Reach out to all of the Code Compliance Board members and plead with them to take their seats back. And just be careful. You have made a terrible, terrible mess of Biscayne Park. It's taken you about 3 years to do some really destructive things. This is not the time for this.
Madam Clerk?
Gary Q.
Derek Hill, 777 Northeast 111th Street. You know, there were a number of things that the village manager said about the Code Compliance Board, a number of allegations that have never been proven or stated, never discussed with the board. You know, Christian came to most of the meetings. Until recently, he used to come to all of the meetings. And for make these kind of statements and come up with this idea that a special magistrate is going to be more efficient, I don't know whether he was asleep, he's just phoning numbers or what. Do you realize how many hours we spent preparing for a board meeting so that we could go through the items more efficiently? A magistrate, either he's going to do that or he's going to sit here for many hours listening to stuff and trying to figure out what it is. The other thing is with a special magistrate, he doesn't know our codes. He's going to rely on a code compliance officer who doesn't know the codes either. Okay, a number of times, and Christian witnessed this, and we stated it, she would make a mistake. She would actually cite something that has no foundation in the code. An example is inoperable vehicle. Not in our code. Derelict vehicle is, but not inoperable. And what constitutes an inoperable vehicle? She actually gave a violation to somebody who's charging their battery on their car. Now the magistrate doesn't know. Okay, the other thing is that, how do you know, I don't know what your reasoning is, what you're trying to do with the community. Our fines, there was a schedule, despite what was said. We had a schedule, we followed the schedule, and there were times that we were more impactful with the fees. For instance, if somebody was doing work without a permit, doing plumbing work without a permit, versus somebody who was doing work, plumbing work, electrical work, and say air conditioning work, that's a big difference. And yes, we might have been, more stringent in that. But when I put that schedule together, I looked at several communities, surrounding communities, and we were maybe 50%, if not less, in terms of the fees that we were charging. I tried to be extremely conservative. Now, you got to listen to some of the North Miami Beach code compliance meetings. they really come up with some hefty fines. I mean, really stiff. Now, I don't know what your process is. I don't know if you're going to stipulate the schedule of fees, or you're going to leave it up to the magistrate, or what. So you're starting out with this foundation, which is a false premise that you're going to do this for $11,000 a year or whatever you're coming up with. There's a lot more work involved if this is going to be done. It's going to be a lot more if it's done correctly.
Thank you. Madam Clerk?
No one else.
Anybody else would like to speak? Last call on the ordinance only. Okay, thank you. Open up for discussion. I'll turn it over to Manager Manners.
Following the Commission's directive at the October 17th meeting, we put together the ordinance for first reading for a magistrate and a code board. We did leave the division, we put in specific items for the magistrate. We did leave the one for the code board vacant so that we can have Commission input on that. And so we can look at that.
Attorney Rodriguez.
A few things. So,
I'm sorry, the mic again. Is the mic on?
um,
I don't think the mic's on.
It's on.
Okay.
It's on? Okay.
And these are in no particular order. With respect to assignment of cases, obviously that's something we're going to need to go through. With respect to assignment of cases, that's something the Commission is going to have to give feedback on today. I know we discussed it in the workshop. I put something together based on your comments, but obviously I look forward to receiving feedback on that. And I did consult with the manager about code compliance cases, and right now it's currently drafted as if it's not specifically delegated to the special magistrate in this ordinance, then it defaults to the code enforcement board with respect to assignment of cases, who hears which cases, which types of cases. So if there are specific ones you want moved from the jurisdiction of the special magistrate to the jurisdiction of the code compliance board, that's something I would like to know in today's meeting. And there was a comment about proposed amendment regarding conduct of hearing. That's on page 10 of 20. That was amended to track with the current version of the statute.
I'm sorry, which section was that, please?
I'm sorry?
Where are you referring to? 14.118?
14.118 with conduct of hearing.
Okay.
Those amendments are to track to Florida Statute 162.07. The threshold issue is really the assignment of cases, because subsequent provisions in the proposed ordinance will have to mirror how cases are delegated. So right now, a lot of the later provisions say special magistrate and code compliance board, but there might be instances where the code compliance board isn't assigned that type of issue, so I would have to remove reference to the code compliance board. Oh, and this is the last thing. Then I'll open it up for questions from the commissioners. But the procurement inquiry came up a few times. So here's how your charter and your code work.
Excuse me. Excuse me. Please sit down. Thank you. I understand, and I respect what you're saying, and she hears you, and we'll work on the mic issue if that's an issue. But please don't interrupt. Thank you.
So, professional services contracts are exempted from competitive bidding requirements in your code. So you don't have to do that. I think we talked about that a little bit in the workshop. The village manager is tasked with hiring staff. That being said, Chapter 162 allows the commission to create an alternate procedure for code enforcement proceedings, which is what this proposed ordinance would do. So you would have the ability through this ordinance to task the commission with selecting the nominee, if that's something the commission wanted to do. However, if you don't address it, the default is going to be with the manager because that's how your charter and your code read.
Could we also have a ratification? So
Well, you
that-
have to do that anyway, no matter which you pick, because the commission has to approve any final contract for execution.
So it's ratified through the contract, okay.
And those are my notes based on, one resident emailed a Coral Gables ordinance regarding qualifications. It's a good idea, but that's a policy decision for the commission, not for me. So if you would like to drill down more on the qualification section on page 2, that's something I would like some feedback on for the final version for second read. Those are all my initial comments, and I'll open it back up.
I'd like the commission to decide if they would like to go through section by section, or do you want to do this one person at a time and give all full comments? I'll leave it up to my colleagues.
Yeah, I'm fine either way.
Section by section.
Okay, so we'll do section by section. So we'll start with section 1 on page 2 of 20. Is there anything on that? I assume not. Okay, section 2, Land Development Code amended. Section 14.1, I'm assuming anything on page 2 of 2?
Yeah, I would say that we should probably include the language, even though can be found elsewhere, but include language under 14.1.3 A1. Just include the language in there about subject to ratification by the commission would be my recommendation.
I have no objection. You have any objection, sir? No? Okay, so noted.
And then under 14.1.3A3, under qualifications, it is a little vague. I've seen other municipalities include language that just states appropriate legal experience or background.
Yeah, I like the idea of,
Yeah,
I actually thought that was an excellent section that you brought forth. Thank you, sir. I think we should look at that and increase the qualifications.
So I'll just mirror that provision.
Can we all agree with mirror Coral Gables?
Yeah.
Okay.
Yes.
Thank you, sir.
And I have one question on that item with respect to, at the workshop we discussed having a professional liability insurance coverage. We didn't discuss the limits. So the way I drafted it, it's with a policy limit deemed acceptable to the village manager. I don't know if you want a threshold coverage amount in the ordinance, or if anyone's thought of that.
What bothers me is as Florida statutes change and liabilities can change, that may be a moving number. We might be able to add some other language and some sort of other language, not just to the manager, but an appropriate, I don't know. I'll let you come up with that. That's not my area, but.
Well, this is for students, so
Well, I'd like to see something that's more in mirror in keeping with, for example, if the governor, if the legislature decides to change something and allow something to have greater exposure to us, then their liability insurance exposure would have to go up. So, for example, they changed the code and allowed, I don't even want to say, don't give them any ideas. But if they made something so that you could have exorbitant fees reimbursed to the claimant, then that would then require us to have somebody who had to hire insurance.
So what about,
if it's not covered by MIT.
What about including a requirement that when the manager presents the proposed final contract to the commission for ratification, the policy limits have to be disclosed at that time for the commission's review?
Perfect. Is that okay with everybody?
Yeah, that's fine.
Perfect. Okay. Now we're on page, we're on page 3 of 20. We'll start with Commissioner Tudor and then work our way down. How's that? Is that acceptable, Vice Mayor?
I had nothing on 3.
Anything on 3 for you, sir?
No, I'm okay with it.
Okay. Page 4 of 20, Commissioner Tudor?
I'll wait till we get to page 5, but nothing on page 4.
Okay. Anything on page 5?
Page 5, there has to be a clearer definition of when cases are going to go before a special magistrate or the code board. The language that's currently here, actually nothing would go to the code board. It looks like everything is front-loaded to the special magistrate. So I think that is something that the attorney was saying that was up to the commission to have a discussion on. I think we need to find out what would actually trigger a case going before the special magistrate and the code enforcement board.
When we discussed this during the workshop, I believe that you had a suggestion, Commissioner Tudor, that it should be the violations, the citations, go in front of the code board. That was what we agreed at that time. Has that changed?
Yeah, and I'm kind of get some input from the manager to see what his feel is on this, what he would think would be a good criteria to define which cases would go to one or the other.
I'm comfortable with the idea that citations would go to the code board as far as that goes. The routine ones that aren't typically debated and rarely a home is leaned upon from those. And so.
Vice Mayor? That's what you agreed last time. Have you changed your tone on that?
Yeah. The way you're saying it, it's almost making it sound like the code board, it just basically it's basically like on I hope I'm explaining.
I'm sorry, excuse me.
Lowest on the totem pole, that they're really not that important. The magistrate is more important.
It's not a matter of putting importance on either the code board or the magistrate. It's a matter of having a professional versus non-professional hearing the cases that create the most liability for the village.
To say, well, I don't agree with that. To say that the code board is not a professional, I think they are. I think the members that are on this code board have, not exact, I can't get, wish I had the exact amount. I'll say maybe 20, 30, over 50 years experience in code.
But currently they've resigned.
Well, but, okay, well, that's going to be another question I'm going to bring up and see if we can get them to come back. But I think we don't know that the new code board is not going to have the same experience.
We don't know that.
Okay, so for that reason alone, I was for originally where I was going to separate it that, but to me, it's just lowering the standards. It's saying basically the code board has no professionalism, or they're not qualified to do it. Then then you might as well just get rid of the code board and just have the magistrate do everything.
Well, that was my recommendation
I know,
initially.
well, but as you know, I'm not in favor of the magistrate. So I think everybody has figured that out by now, that I'm not in favor of doing this magistrate. I still think we should have the code board. But since we're not going to have just the code board, then I want to have we're going to have both the magistrate and the code board. But I also don't want to have the code board just basically be, and I don't believe that's your intention, to have the code board just be a nobody and they get the small little cases and we'll throw little crumbs at you. If that's the case, I don't think you're going to get anybody to join the code board. I think we need to use the experience that the code board has. And I'm using the experience that we had in the past, because that's the only one we don't have. We don't know what the new code board is going to do. We might have more experience with the new code board, and we might have less. Hopefully, the people that are going to want to be on the code board are going to want to be on it like this group of people are, because they want to really believe in doing it. And that'll be up to the commissioner to determine whether or not that person has experience, because I do agree that the commission should be picking each member, should be picking one member on for the code board.
That's up to the commission.
I'm just saying, that's what I'm in favor of. Okay, so for right now, that's what I have to say about that.
My last comment is just that I agree that it has to be defined roles between the two so it's clear. I don't believe that individuals should select. I think that was direction we all agreed on last meeting. We've had but this is the first reading of it. Of course, we can change it if that's the will of the commission. It is not my wish. It is to either have very defined roles. As you know, I supported having one or the other just because of the size of our town and the cost. I still believe that is the case. I would still go with either special magistrate or both, but not both, and I support a special magistrate at this point. Having said that, we've already had the attorney draft a first read. I'm willing to support what the commission agreed last time too. So, Commissioner Tudor, I'll turn it back to you.
Yeah, for me, I just need to see a little better breakdown on which cases will actually go before the Code Compliance Board. I think if we had the language in there that would identify that, it's easier for the commission to understand and for residents to understand exactly what the role of the code board would be. I know my fellow commissioner's concern is that if the matters that go before a code board are are not of a certain importance, or crumbs, or matters that we should just then have a special magistrate, then that's a discussion that may be where we end up going anyway, if there's no interest in the code board. And but for me, I just need to see. I was hoping for this first draft that there would be a little bit better of a breakdown on what the different cases would be going before each.
If I recall correctly, and correct me if I'm wrong, but the agreement that was decided last meeting was that it would be citations. I do have a concern, which is kind of not on this page, but I brought it up because I think citations aren't just $25, garbage collection fees. You can have citations that are associated with safety matters, and that is something that I think our code has a problem with. Please allow me to finish, and please don't interrupt. Thank you. I think that our code does not define that, and yet Florida statute allows for it. So I do think we have some issues with our code where if you have major safety issues, that fines need to be allowed to be assessed in order to stop that violation. And I agree that our code may need to be amended to have that happen, but that is why right now under section on page 8 of 20, where it says number 8, these are the only 8 things that the code officer can issue citations for, according to this. And I do think, for administrative citations, I do think we need to look at safety issues such as septic tanks. It could be a variety of issues, construction issues. I think those things need to be addressed, and I don't know if that would go in front of the special magistrate or go in front of the code board. So those are issues that I have with that.
For purposes of what gets assigned to the special magistrate, is there anything?
I'm sorry, your mic for some reason is not working. Can I get you another mic?
With respect to,
there you go.
I'll project a little more. With respect to the draft as to what types of cases would be assigned to the special magistrate, is there anything the commission wants to move to the code compliance board?
This.
Because that's a place to start. Okay. Oh, much better. Thank you.
Much better.
Is that something we could do today because it is there?
Could you point to the section so we'll all be on the same page?
Sure. It begins on page 4 of 20.
One of the questions I have, is there any way so we could avoid having an attorney sitting at those meetings to create it so that, here's my concern. I know it's advantageous to have a attorney at these meetings, but if we limited it so that we didn't have to have that fee, that would be less problematic.
There is no scenario where I would recommend that the village not have an. Hello? No, it's back. Okay, so there's no scenario where I would make that recommendation. I'm a licensed member of the bar. I can't advise the commission to do that.
Okay. Commissioner Tudor?
I think the Vice Mayor.
I don't believe we need to have an attorney at every single code meeting. We didn't have it in the past. We didn't have John Hearn, and he's been around for 20 years. He wasn't at every single meeting. There's items that you need to have an attorney present, and there's other items that you don't. You have the city manager there that represents the village. He can make decisions on what needs to be made. We just don't need an attorney every single time at every single meeting. I just don't believe it.
Well, if you're going to have an attorney at a meeting, it can't be our attorney sitting here or the manager. It actually has to be somebody who's going to be providing legal advice to the board. It has to be somebody independent, because the manager and the attorney, just in the nature of their duties,
Represent the village.
they are working with the code officer. They're involved in the cases that go before the code compliance board, so it would have to be a separate individual. Now the question is, are there cases that the inherent risk is so minimized that an attorney would not need to be present for a code board meeting. I guess that's really what we have to have a determination of. My understanding right now is that our attorney is saying that she wouldn't recommend having any type of code hearing, since it's a quasi-judicial hearing, having that without the village having some type of legal representation for the board. Now, I know we haven't done it in the past. That doesn't mean anything. There's a lot of things that we've done in that we've done in the past that we haven't done correctly.
Yep.
Part of our role here, and I've heard rumblings from some of the same individuals that somehow this isn't what's best for the village, and that this is personal. The commission's role is to look at how best to minimize risk for the village. That's one of our roles that we should be doing. The fact is, when it comes to these type of matters, it's better handled by a professional outside third-party special magistrate handling the matters. And we're not discussing this right now, but I even take that further. I would like to see other areas that our village currently operates brought into in-house into a professional setting. So these decisions and this whole conversation about a special magistrate is not a personal attack on any resident, any individuals who sat on the board, or anything along those lines. Now, I can't speak for the rest of the commissioners up here, but the idea of utilizing a special magistrate, in my opinion as a commissioner, is that this would better minimize risk to the village.
I concur with that thoughts, and to answer one resident's concern, I've been on boards, I've served, I volunteered, I know what the donation of time is, and I know that many of these board members have sincerely put forth enormous amounts of time into this village and to make it a better place. I don't, for 1 minute, take that away from them. I do think, I agree that just because we haven't done it in the past doesn't mean we shouldn't do it now. Regarding what gets separated between the two, that was my concern in the first place. I think it should be very clear, very determined, whatever it is that the majority of the commission wants to do. I don't think it should be a selection process of which one they go in front of. There's no point in doing that, and there's no point in having a special magistrate or a code board having both. If you're going to split it up, make it clear. The attorney is asking for our direction tonight on what goes where. We have to make that decision. So if we want to, let's go through it and decide what goes where. It starts on page 14, it's 14.1.4, correct?
Begins on page 4 of 20 at the very top.
Okay.
Excuse me. One of the problems that I'm having here, I don't know what makes this commission think that you're more expert than people that have been in the past. This has worked for whatever amount of years we have had the code board. For this commission to decide just because it hasn't been done in the past doesn't mean, I mean, you know, the past is not correct, so we're going to start doing it in the future. Right now, having this discussion with only 3 commissioners, I have a major problem with it. Now, I know we spent money to do this ordinance. I wasn't counting on another commissioner not being here or one commissioner resigning. I'm having a major problem discussing this item tonight with 3 commissioners. You know. So.
With that,
real quick, I've heard the comment about that there's only 3 commissioners up here. That's still a quorum. We can still have meetings if there's still 3 commissioners up here. So there's, you know, the conversation that there shouldn't be a meeting because there's only 3 commissioners present, that's a quorum. We're allowed to have meetings, we're allowed to have this process go on with 3 commissioners here. Now, would I like to have both 2 other commissioners up here? Yes. But, you know, right now we're working with a quorum. But it's 3 commissioners up here.
You're right, but the 3 commissioners are deciding the finances of the residents of Biscayne Park. I mean, whether or not what fines and what, you know, what code. I mean, 3 commissioners doing it.
But we're
bad
here-
enough-
but we're
so
here
tough
now.
enough to do when you have 5 commissioners, but to do 3, yes, you have quorum, and you can make decisions, but we're talking money here. We're talking a lot of money that we're going to be holding residents responsible for.
We've
I don't
advertised
feel
for a first reading of an ordinance, sir, and so I do believe we have to move forward
No,
with this. You can vote against it if you'd like, but I do think we have to move forward with it.
I'm just expressing what I'm expressing, that I don't feel comfortable going forward. Doesn't mean that I'm not going to make the decision. Yes, I said it, as I said before, we spent money on the ordinance, so we have to go through it. But at this particular moment, I don't feel comfortable supporting this at all.
Okay. So irreparable violations, should that belong, actually 1, 2, and 3, do we agree that all of those should belong with the special magistrate? Would you want to move any of them? Do you want to go one through, this, we could be here quite a while, but
Yeah.
how would you like to do that, Commissioner Tudor? Can we agree that items 6, 7, 8, 9, 10, 11, are all definitely within the purview of the special magistrate? And 13 as well. So right now I have 6 through 13. Actually, 14 goes into that too. I'm trying to find things that are legally complex, and I don't want to be the one making these decisions, but Attorney Rodriguez, you can give us guidance if you care to, but it looks to me like 6 through 16 should definitely be within the purview of the special magistrate. And Manager Manners, please feel free to weigh in as well.
I agree with you, and that's why, right now we have it written that way.
Okay, so really it's 1 through 5 to look at those particular ones. I also think 4 is definitely under consideration because that's a continuing violation, and that's running penalties. I would also throw 4 into that. Commissioner Tudor and Vice Mayor, if you have comments.
Give an example of what that
I'm going to leave 1, 2, and 3 for the attorney to go through, if we may, and 5. If you all agree that 4 and then 6 through 16 are definitely special magistrate. Start with Commissioner Tudor.
The only ones, 4 and 5 would be the only ones that could possibly be handled by a code compliance board. But,
I'm sorry, 4 and 5, okay.
yeah, those
I
are
see
only
what
ones
you're saying.
that, from a debate standpoint, I think could be had regarding falling in between one of the 2 boards.
Okay, so 1, 2, and 3 will agree stay in with the special magistrates, so we're looking at 4 and 5. Is that correct?
Yeah, looking at 4 and 5, I'm still looking over 12 and 13.
Could you clarify 12 for us? Attorney Rodriguez?
So there can be instances where there's aggravating or mitigating factors being presented in a quasi-judicial proceeding. So there's more, you're giving evidence weight and you're weighing what each side is saying. It can be used in certain instances to be more heavy-handed or to be more lenient in what you impose against the respondent. So those are probably the two most iffy ones for me as to where they should be assigned.
So you would recommend
But there
those
is a
to sign?
finding of fact that would take place in those instances. That's why I initially put them there, but they could really be in either. But that's why I initially put them with the special magistrate, because the findings of fact that need to be, they would have to address that and say what weight was given to the presentation of aggravating or mitigating circumstances.
I then would then recommend we keep them where they are. And then, could you go over 4 and 5 for us, please? And then we'll agree or disagree.
Okay, so the reason I initially put these with the special magistrate, because continuing violations and repeat violations can impose more serious penalties because it's something that isn't being corrected. And I don't know, village manager, if repeat violations and continuing violations are a real problem in the village, but
Sometimes, yeah. Sometimes repeat violations in particular.
Okay, Commissioner Tudor, I'll turn to you, then Vice
Sorry,
Mayor.
one more thing. It gets more punitive the more the person has to come back over the same thing. That's why I initially had it with special magistrate.
Both 4 and 5?
For 4 and 5.
For 4 and 5.
Now, 4 and 5, I want to take out of there.
And I want them to stay, so Commissioner Tudor, that's on you. And Attorney Rodriguez, your recommendation, or do you have one?
For me?
No, I said, Attorney Rodriguez, you have a recommendation is to keep 4 and 5 where they are?
Did you want to say something, Commissioner Tudor?
go ahead.
Okay. I mean, because it's going to be a finding of fact that's potentially going to be appealed, I think it's more appropriate with the special magistrate, but it's up to the commission, obviously.
Okay, Commissioner Tudor?
So what matters would come before the board that would not involve findings?
No, they all would, but the findings of fact as to repeat or continuing violations would be the basis for potentially a more punitive ruling in certain instances. So if that were to be appealed, I think the more prudent thing would be that an attorney was the one drafting it, because when you get into continuing and repeat violations, it gets more intense, right? So, and there's a greater risk for litigation on those types of issues.
So you're saying that for the code board, what would be create less risk for the village would be something along the lines of an initial single violation, not a repeat,
Exactly.
not a continuing violation.
Right, as it ramps up, I think it mitigates risk to have that reviewed by, a licensed member of the bar, and for that order coming from the code enforcement proceeding to be written by a member of the Florida Bar, in anticipation that that person might want to appeal it to circuit court for review. That was the spirit of what I initially delegated in this draft, based on the feedback I received in the workshop.
Now, I can understand the rationale for putting that underneath the special magistrate, just because it's an escalating situation that can be created, but
That's the right word. That's exactly what I was thinking, yeah.
so what language should we have in here that would, what language from a legal standpoint do you think should be in here underneath the code compliance board if we wanted to handle code compliance board handling a one-time initial violation. It's not a repeat. It's not a continuous violation.
Like a violation of first impression, that we could use some language like that, that it's the first time.
Could you put something, because I think the point that the residents were making, and I happen to concur with them, is that it doesn't specify what they're to do. It specifies what they're not to do. So I think some initial language in there identifying that so it's clear would be probably more helpful.
Okay, so, Village Manager, what are your thoughts on something to say, first citation, first notice of violation, something like that, to make it clear that it's, it's
And
the
you can
first
also put a
time.
monetary limit on it so that the exposure is not as significant. I mean,
Well-
that's the other option.
Well, on that note, that's kind of in subsection 16, and that's something I want to make sure the commission's comfortable with number-wise.
Okay,
There
well-
is a threshold for things that have to be bumped up to, to the magistrate review, which is the 5,000. But if you think that should be more or less, I just thought it was a nice round number to get feedback on. I don't know if...
And that's on page...
That's on 5 of 20. It's subsection 16 of the special magistrate assignment section.
Because there's going to be matters that, what I don't want to end up doing is, because of the cost of the special magistrate, I don't want to end up potentially overloading a special magistrate with smaller, simpler cases. I really feel that special magistrates should really be more focused on the issues, the cases that are really going to put the greatest jeopardy to the village. Some of the ones where we're talking about smaller fines, we're
Yeah.
talking about it's
Like
an
over the
initial
code board.
violation. They haven't come before. It's not like it's a repeated violation. Those are something somebody should be able to come to before the board. It should be, and it can be judgment, or the matter can be remedied, quickly, as opposed to bogging down a special magistrate with potentially some of these simpler matters. Because as we try to ramp up, and if code were to, if there were to be a change in the code department where all of a sudden, now we have a second code officer, and let's say they're both out there, and we're starting to see more citations, more violations coming in, I don't want to overburden, and I don't want to tie up resources with the special magistrate on those type of cases. That was my initial thought of having the two. The other reason why I think we need to have the two currently is, I think we want to have that option available to the village if we find that the special magistrate process down the road for another commission, or we find that it's not the best course of action after we implement it. We still have the code board here in existence. But that
You'd
was
still
my-
have to have an ordinance, though, to remove it. You'd be back right where you started from.
Yeah.
I don't think the idea was either or, which is what we had talked about initially, having one or the other, and then that's what I originally had thought. We'd try one, and if the special magistrate doesn't work out, we could then reconstitute a code board. But originally, that was my thoughts behind having one or the other and not having both.
Yeah, and I've said it before. I think it's probably better for the village to have both
As you
available.
wish.
But it really comes down to specifying the cases that would go before the code compliance board. We have everything laid out here for the special magistrate. I mean, but we need to have, I think.
Well, it's a threshold of 5,000. Anything under 5,000 would go then to the code board, correct?
Well,
Except for these conditions that you have here.
Right. The code board would hear everything else. That's what, that's the first subparagraph of B. Any code proceedings not specifically delegated to the special magistrate's jurisdiction shall be within the jurisdiction of the code compliance board. So they would be getting anything that didn't rise to the level of one of these factors.
Yeah, okay. That I like. I mean, I like if it's 5,000, but what would make 5,000? I mean, what, if you're saying that $5,000, what kind of fines would that be that would be considered for 5,000?
I misspoke.
Because if you're saying that, then that doesn't mean we're going to have I don't think there's a lot of fines that are...
I misspoke, Vice Mayor. I misspoke. It's 5,000, but also it's any of these other conditions. So I misspoke when I said that.
I mean, there are certain, if they're an irreparable, irreversible violation, you can fine up to death. For instance, say someone cuts down a protected tree, that sort of thing. That tree could never be replaced. You can't just glue it back. And so that would be something, that is irreparable, and you can do a higher, fine with those.
Right, but is that under our, if it's a Dade County tree, wouldn't that be Dade County that decides that there's a fine?
Possibly. I mean, right now, you can cut down pretty much.
No, I'm
Yeah.
using it as, if it's Dade County, if it's in Northeast 6th Avenue, that belongs to state, right?
Perhaps not go into specific violations so that we don't misspeak.
I'm
Yeah.
trying to figure out what you're coming up with this $5,000, because I like the amount, $5,000, but I don't think we have too many cases that are 5,000. So if we go by that theory and the code board gets everything else, to me, there's no purpose of having the match.
So that's the threshold amount that could get you your matter assigned to the special magistrate, but there are other things as well.
That's why I misspoke.
Right, so like 1 through 15 are all the other instances that would require that the clerk to assign that hearing to the special magistrate.
I like to have it where the resident can decide if they want to go in front of the code board or the magistrate board. Some residents might think, okay, it's better to deal with one person. I have a better shot of hearing my case than to go in front of a whole board. Or it might be a resident who wants to go in front of a board thinking he's got a better shot of hearing. Because the purpose of, I believe, code is to get people up to compliance, not to try to make money.
Right. You're absolutely right on that.
That's what I ran on, okay? And so if a person feels comfortable going in front of a code board to hear his case, they should have that option. If they feel comfortable going in front of a magistrate, you only have to answer to one person. The other one you have to answer to 5. You have a better shot of 5. I'm just using that as an example. I want where the resident has a choice between the two.
Sure. Right. The problem you're going to have with that is they're going to go where they think they have the best shot of winning, and then if they don't win, then it's going to be a big fight.
Is the code board you're saying are not going to want to get the people up to compliance? I mean, of course, I would want to go in front of a person, a jury of, if I'm on trial for murder, I'd rather go in front of a jury of 12 than to go in front of just a judge. So, and I'm not comparing the residents for that murder, but it's just as an example. Of course, they're going to want to go in front of a code board because they have a better shot of doing it.
Not always, no.
Well, okay, so that's what I'm saying. They should be able to have a choice between a code board or the...
Okay, just to straighten this out so we have this done, we had originally agreed when this was drafted that we were not going to do that and there were going to be delineations between the two. I am not in favor of what you just said. I'm going to let Commissioner Tudor, are you in favor of switching this now to a choice?
No.
Okay, so that's not going to happen. Okay? As currently commissioned.
Yeah, no, for me, I just want to see, as opposed to the code board, the cases that go before the code board, instead of it just being, a negative, not...
You want the specific, what is?
Yes, I want it to actually identify the cases or type of cases that would go before the code.
Can you work on that?
Board.
We can, well, we should discuss it now because this is first reading, so we can add language saying that any preliminary citation or first violation goes before the Code Compliance Board, but I really recommend you leave that catch-all in there afterward.
That's fine. I have no problem with that. The only thing is I think you should also, as long as it doesn't go, because if it's a large violation for whatever reason, I just want to make sure that the 1 through 16 are covered as well.
Okay, so if I could get a confirmation from the commission on that now, because I asked if anything should be moved.
Well, I made it.
And from there to B, and Vice Mayor Samaria, I think you said.
4 and 5.
4 and 5, but I didn't get any other feedback on that, so can we get a vote on each of these as to which?
So I'm against it, he's for it, and Commissioner Tudor, what do you want? You do 4 and 5.
No, when we had the discussion talking about 4 and 5 and how it can create greater legal liability potentially for the village, that I think that should stay with the special magistrate.
Okay. So
I'm fine with including because you're talking about you want to keep the catch-all where identify the case that would go before the code board, but then you want to include that any of the code proceedings not delegated.
Right.
About just if
Right.
if there anything else that falls that doesn't fall underneath that, I'm fine with.
Okay, I'm fine with that as well. And Vice Mayor? Yes?
Yeah.
Okay, so that's 3 yeses on that.
Okay, and then with respect to all of the other items that are being delegated to the special magistrate, is there any
That's all.
discussion about moving any of them?
No, it was just 4 and 5, and the rest were agreed to stay,
Okay, and then I am amending...
if I'm not misspeaking for my colleagues.
So for 15, it says where, so if a resident comes with legal counsel, that has to go in front of the magistrate, can't go in front of the code board, right? Because that's what it says here. All procedures would have responded will be represented by legal counsel. That
Yes.
means if I bring legal counsel, I have to go in front of the magistrate, not the code board.
Right, and once this ordinance is finalized and adopted, what we're going to have to do is amend the hearing request forms to accommodate these new procedures so that the clerk will be able to identify how she needs to assign the matter when she's preparing the docket for these hearings. The reason why I put 15 in there is because if someone's hiring an attorney for a routine code compliance matter, that should be something the village takes note of, and it's my recommendation that an attorney be the one presiding over the proceeding. That's my recommendation, but...
Okay, so 15's up for discussion. I vote it stays where it is. Vice Mayor, you wanted to move it?
Yes.
And then Commissioner Tudor.
I would leave it with the special magistrate.
Okay.
I don't think 12 and 13 are the ones that, I don't know if that language is actually, is it necessary to have that in there? Because, because, for example, respondents shall present mitigating circumstances. In any case, 9 times out of 10, somebody's going to be presenting, a mitigating
Right.
circumstance.
Every respondent's going to have a mitigating
Yeah. So
Those were the most middle of the road, those two, 12 and 13, were the most middle of the road factors that could go either way. And a lot of these that are going to be before the special magistrate, those items are going to come up anyway because it has to do with continuing violations or repeat violations, and those factors will be before the special magistrate anyway. So, I don't think it's terribly detrimental to remove 12 and 13 if that's what the commission wants to do.
I think it should be removed. I don't think there's a need.
I'm fine. We can remove it. It's fine. All 3. Okay, now we'll turn to page 6 of 20. Is there anything on 6 of 20? We'll do it this way this time. Vice Mayor, anything on 6 of 20? Actually, might as well do 6, 7.
With 14.16 council, I want to have a language where we don't have to have the council there to be saying, is that what it's saying there? Maybe I'm reading it wrong.
No, it's just reiterating what the statute says. If you're wearing the hat of village attorney, you can't also wear the hat of
So
that counsel to the board.
So that means that we have to then go out and hire another attorney to do it. Is that-
If you decide that the code compliance board should have counsel, it can't be me.
But it has always been the village attorney.
I don't want to speak to how past attorneys have given legal advice to the village, but it can't be both.
Yeah, I would argue it probably should not have been in the past.
Okay, so 14.1.6 stays? I vote yes.
Yeah, I'm fine with leaving that in there.
Vice Mayor?
All right.
Okay, it's 3 yeses. Compliance procedure, anything on compliance?
If I may, just so you know, that echoes the state statute, 162.05.
It's just the same language.
It's the state's.
Okay.
14.1.7 compliance procedures. Is there any questions on that? The only one that I had, if I may, is the same one I had before, which is, I do think we need to address the issues of safety and administrative citations. I'm not sure, originally I had thought of adding a number 9 on page 8 of 20, but after discussion with you on this, that's not the appropriate necessarily way to do it without amending the code.
Right, so the code compliance officer can only issue violations to provisions of the code that exist. So if you want certain other protections in the code so that so the code compliance officer is empowered to give violations for certain things, the first step is amending the code to make those things violations. Then circling back to the procedures on how to enforce it.
Yeah, my concern, and I just want to make sure that you have to balance it. What I don't want is the code office to have blatant right to do anything, because that's just ripe for abuse. At the same time, since I've been in office, there's been a number of occasions. Please be respectful. There's been a number of situations where there was a construction issue that created a safety violation that was major. There's been other cases that came in front of the code board that had to do with sewage and things like that. So these are situations where you ended up having to fall back on the statute because we didn't have anything in our code. And part of the problem with our code is its absence of a lot of things, and then we're playing the game of, well, it's not in our code, but the state allows us to do it. What I'm trying to do is not limit the code officer for serious violations. We've had rave parties where the most they could give is a $25 fine for 300 kids throwing up and putting, cups out on the lawn. And the only thing they could do is a $25 fine.
Well, that's the sort of thing that you would conversation at another meeting about amending the code to make those, specific prohibited items in your code so that it would empower the code enforcement officer to enforce that.
But so we don't have to rewrite this and have another reading of this, can we put something in here that says, or something that's not a catch-all, but something that would allow us to say anything else that's then in the future cited in code? Because I just don't want to have to rewrite this over that.
So subsection F is dealing with irreparable and irreversible violations. So, I'm sorry, 8 of 20?
Just in the different sections, my concern is if there's a change, we don't make this an outdated document before we get started. That's all. And if you could look at the sections.
So you're saying make us, so you want a subsection 9 on page 8 of 20 to say something like any other violations of the existing code?
Let's put in there. I'm just trying to, what I'm trying to do is make sure that, and if I'm wrong, tell me I'm wrong, I'm fine with that. But it would seem that if we're limiting it to only these 8 things, therefore nothing else can be written for. And if we end up changing or amending the code, whether it's for short-term rentals, whether it's for construction, we're not going to have a place if it's a situation in that subsection.
Can you repeat what you wanted to do for 9?
Anything else that's also allowed to be done by code, citations written by code, just something that puts that in there. Or change the sentence that's prior to it. And determine whether an administration citation or notice of violation for the following offenses or any other offenses. I'm just trying to make sure we're not outdating this, that's all, before we start.
How I mean, do the other commissioners have feedback on that before?
Yeah, before she offers?
Yeah. Commissioner Tudor?
What were you going to say?
I mean, I know the issue. I mean, I've met with the code enforcement officer. It's true, the village has like a one-page form, and it's these 8 things, and there's check boxes, and that's it. So I've seen what the mayor's referring to. It's true. It's limited to these items currently, but I mean, village manager, what do you think?
No, I think...
Because this is a practical, day-to-day
When it
thing.
comes to giving fines, like citations, which are finable offenses immediately, I think we do need to have limits there. We do need to specify specifically.
No, I have no problem with the limits. My problem is that if you change the ability to write a citation, this ordinance is now outdated because it doesn't have that in there. You change your code, you now have to update this at the same time.
Okay, so, village attorney, how would we do that to allow for future adjustments without having to pass another ordinance? Or would that ordinance be passed in code updates?
I mean, You could, as you amend your code, you could add to this. It could all be done in the same ordinance. You're not limited to one section of your code when you're doing an ordinance to amend your existing code, but,
we're
I
in the
mean,
middle
is
of
there
writing-
are there specific recurring?
Yeah, we're starting to look at, a construction ordinance is supposed to come up, hopefully. We're waiting on that. We've got driveway possible. You have other issues here. I would just like one line in here that says, or any current updates that allows for citations and codes, so that we're not having to rewrite this one subsection. That's all I'm asking for.
But if it comes before the commission, let's say we, add another, I'm trying to think of something, parties at a house. I'm just going to throw something out there. Because if you're going to include it, I don't know if there needs to be any change on this. I mean, you can always
That would be changed in the future.
Yeah, you can always just.
You have to
amend.
advertise 2 ordinances now. The cost of that is going to be double, or no?
No.
Okay, just want to make sure.
Yeah, so like, let's say
If I'm wrong, then tell me I'm wrong, it's fine.
Let's say you want to amend your code later on to have a provision about loud parties. The ordinance amending your code to deal with that can also amend this section. You're not confined to
I'm
one.
wrong, that's fine, I'll withdraw.
Yeah.
Okay. Anything on, finishing on 4.1.7, anything else? I have none.
Yeah, I don't have anything till 14.1.8.
Nope. Okay, 14.1.8, let's start with Commissioner Tudor on this one.
Page 11 of 20. We still have the same language. I don't know, about the village commission shall provide clerical and administrative personnel.
I'm sorry, could you repeat that, sir?
Yeah, it states here that the village commission shall provide clerical and administrative personnel as may be reasonably required by the special magistrate or code compliance board.
So that's right out of the statute.
Okay.
We don't, if that's something you're not comfortable, we can remove it. This was taken straight from the current version of the statute to bring this section of your code up to the current state law.
Mm-hmm.
That's what the statute says. That's why it's there.
Okay, so that's per the Florida statute?
That's
Yes.
standard.
Is this good, yeah, that question I have is that cost going to be, so the clerk would have to attend?
That wouldn't be the clerk. We would have Claudia attend, or,
Okay.
we would have Christina there and.
Okay, so that'd be administration, okay, just want to make sure. And I have no problem with it.
And then on the same page, item B, just talks about each case before the special magistrate or code compliance board shall be presented by the local governing body or attorney or by a member of the administrative staff of the local governing body. And we're having a conversation that currently, for most of these code cases, it would be the code officer that's presenting the case. If she's unavailable, it could be the manager. So I don't know if I would be inclined to remove the local governing body attorney and just have that it'll be presented by a member of the administrative staff.
I agree.
Can we do an or on that in case we do, can there just be an or in case we do need to have a local governing attorney?
Just, this is a copy right out of the statute, so if you want to tweak the language, you could make that an last resort kind of thing at the end, but that's what the state statute says. It's a copy paste from the state statute. But I understand what you're saying. You're saying you don't want to incur attorney's fees unless there's absolutely no one else available to present. I get that. So we can add a sentence after that without, running afoul of the state statute that says, that's a last resort in the event the following cannot present the case.
Yeah, it's just when the state, when they probably didn't even take this consideration, but when you're reading it by it being the first.
Can we put it in front of it, right?
It would identify, most people look at it as the
Right.
primary
Can you put it
and then
first?
the
Yeah, I'd either
secondary.
like
So
an
we can
or.
flip it. I mean, that,
I'd
as long
flip
as they're
it.
both in there, then we're not, so. One, a member of the administration of the village, and then, or, if they are unavailable,
Yeah,
to the, by the village attorney. So that way it's, like, some language shows it's like, only in the event that a member of the administrative staff of the village is unavailable to present the case.
If you, please. Thank you. Point taken.
I mean,
Repeat.
if the clerk is not available to present the case, we don't need an attorney there to do that. I can do that as the village manager.
Right.
And so,
So we could just do village, can we do village staff or village?
That's what it says, administrative staff of the
it
local
says
governing
administrative
body.
Yeah, it
staff.
says
That could be,
administrative
So that could be,
Yeah,
Claudia,
that could be,
Christina,
just,
myself.
I switch, can we just switch it? I agree with you.
Yeah,
Can we just switch it?
Yeah, you could just switch it. I mean, for the intent of what we're trying to accomplish in a way, it probably should have been written, would have been administrative staff, the local governing body, or the local governing body attorney as needed, something along those lines, possibly.
Okay,
Yes.
so I'm switching the order, and I'm saying each case before the special magistrate or code compliance board shall be presented by a member of the administrative staff of the village, or, and only in the event of unavailability, the village attorney.
Say that again, the last part? One more
Um,
time.
So we're flipping the order to say shall be presented by, one, a member of the village administrative staff, or, and only in the event of unavailability, two, the village attorney. So it's almost like an emergency situation, but it's not the first thing, because I see what Commissioner, the way the statute reads, it sounds like the attorney's supposed to do it unless, and then, so
Right.
I can flip it without, I think, running afoul of the statute, because both are still there.
Yeah, if we can
Okay.
flip it without causing any
Okay,
type
so-
of conflict
Agreed.
with
Do we all
the
agree?
statute.
I agree.
Okay, so I'll amend it to have that language
Okay.
for second read.
And then next? Anything else on this page? Commissioner Tudor?
No.
Vice Mayor?
Give me a second, please.
And this is straight out of statute too, correct? The remainder of this?
You're on C?
Yeah,
C and D.
C and D both.
C is slightly edited to say that all testimony shall be under oath and shall be recorded, which we're pretty much already doing.
Okay.
Shall take testimony, that's from the statute. Okay, yeah, the only thing that's added is that all testimony shall be under oath and shall be recorded. And that's to build the record in case someone appeals the decision.
Right.
Other than that, that C is straight out of the statute.
Okay.
No problem. Agreed. And D?
At the conclusion of the hearing, the special magistrate shall issue findings of fact. Yes, I added the word written. The statute says shall issue findings of fact. I wanted to make clear it needs to be written
Written
findings of
findings,
fact.
Yes.
In the event of equipment failure, then the person doesn't have a record, and that would be on us.
Great.
Based on evidence. Yes, this is the statute. This is the statute. You'll see towards the bottom, I amended it to say specifically Miami-Dade County because that's where we are.
Right.
But, and I changed language to affidavit acknowledging compliance. I like compliance affidavits. They're sworn to under oath. I think they're just much cleaner. They have an order acknowledging compliance in the statute. I like affidavit of compliance for me, but,
That's fine.
because then
I have no objection.
it's sworn.
That's
No objection. It's on the record. It's
no objection.
under perjury,
No
that's better. Okay, anything on 14.1.9?
No.
No, not for me either. Anything for you, Vice Mayor?
check. Thank you. Hold on. Yeah, I'm okay with that.
Okay?
There's a slight typo in 14.1.10 under A, where I underlined special magistrate or code compliance. There's a missing C. I caught that. It'll be corrected for second read.
Okay, thank you. 14.1.1, duration of lien. On page, 15 of 20. I have no objection to that whatsoever. Anybody else?
No.
Vice Mayor?
No, that's okay.
Okay, 14.1.1.2 appeal. I think this is very important. I just want to ensure we're Florida statute completely on that one, the appeal process.
And the Florida rules.
Okay, thank you. Are there any objections to 14.1.12 for appeal?
No.
No for me either. Vice Mayor?
No.
Okay. Then we're looking at 14.1.13. Vice Mayor, do you have any objections? And Commissioner Tudor?
state statute.
State statute?
If it's not underlined, that's your current code. We're not making changes. That might help.
Yeah.
Okay, so we'll go back all the way to Chapter 15, enforcement. I have nothing there. Actually, I have nothing further on anything. If anybody does, let us know. Vice Mayor, anything else?
No.
Yeah, the only thing this goes back to page 4, 1, 2, and 3, irreparable, irrevocable, and irreversible, just defining those items. I think,
Okay.
You know,
Yeah, that would be better, because it's clear. You're correct on that. I agree with you on that. You agree? Yes. Okay. So we're all in agreement on that.
That's the concern.
Okay, with that, with those changes, there's a motion to, accept ordinance, 2019-05 with the amended changes for second read.
yeah, I make a motion to accept ordinance number 2019-05 with the stated amendments.
Is there a second? I'll second it. All those in favor?
This is,
I'm sorry, there's a roll call for this, my apologies. Roll call, Madam Clerk?
Mayor Troopman,
Yes.
Vice Mayor Samaria,
no.
Commissioner Tudor,
Yes.
Passes 2-1. We're now on Resolution 2019-26 special election. We're going to open up public comments prior to that for that resolution only. We're going to do good, we're doing good and welfare now. We did the ordinance first. It was just done out of order. So we're going to open up public comments. If you have not signed in, please do so. Madam Clerk, please call the first public comment.
McDonald Kenneth,
Is it? Is this on? Yep.
Yes.
Scared myself. Ready for me? MacDonald Kennedy, 11705 Northeast 11th Place. Regarding the election, last week we learned that Betsy resigned from the commission, prompting an election to replace her at the steep cost of $16,000. That's fully 65% of the unbudgeted expenditures in the professional services portion of our budget. I am respectfully requesting that Jenny Johnson Sardella also resign. During Jenny's tenure on the commission, my confidence in her has decreased dramatically, not because of anything she's done, but more so because of her lack of engagement with the position, demonstrated by an empty chair again this evening, I believe 4th meeting in a row. For 3 years, Jenny has failed to show up in the figurative sense of the word, contributing fewer original ideas for the village than any other commissioner. 0 initiatives 2019 year-to-date. This year, Jenny has also failed to show up literally, missing nearly as many meetings and workshops as she attends. 60% attendance rate year-to-date, and leaving other meetings early, all while continuing to contribute virtually nothing when she is here. Jenny now simply fills a chair on the dais on a part-time basis. No reasons for missed meetings are provided, and you never even discuss it. At this point, Jenny is failing to meet the minimum requirement for being a commissioner in Biscayne Park, showing up, literally and figuratively. Although she's not here to face me as I call her out, I did email this message to her and got no response, of course. Biscayne Park doesn't deserve better than Jenny as a person, but we certainly deserve better than what she's able and or willing to give at this point for whatever the reason that we never hear. Betsy has forced Biscayne Park to run a special election at the cost of $16,000. Jenny should take advantage of that special election and resign now so we can fill 2 seats on the dais at the same time. Allow another resident with the time and interest to work on behalf of this community. Jenny won't cost this village a penny, but she will afford us the opportunity to have the representation we deserve and that she promised when she asked us to vote for her 3 years ago. Jenny broke her promise to Biscayne Park. She's not even showing up. If Jenny missed 40% of staff meetings at her law firm without giving any reason to her boss, she wouldn't be asked to resign. She would be fired. Anyone would be, rightfully. In this case, Jenny's boss is the Biscayne Park public, represented by you, our commissioners. It's time for you to take steps to fire Jenny Johnson Sardella if she doesn't care enough about this community to resign. Use the powers granted to you in the charter to get rid of Jenny Johnson Sardella if she won't resign.
Next.
Dan Keys.
Dan Keys. With regard to the ordinance that you just passed, there was some discussion about the language regarding whether or not you could have an attorney present the cases in front of the board. The language was fine in the document that was written. It gave you the choice to use one or the other. If you have an extremely complicated case, you need to provide yourself with the opportunity to have an attorney there to present the case as opposed to your code officer. I have a question regarding Commissioner Sardella, and that is whether or not you have a duty to bring the issue of her absence to the commission, to accept or not accept her reasons for absence. You know, it's a duty. She's not here. She's not participating. I know that, you know, I understand that there may be some issues in her family, etc., but she's not here, and you have a duty to run a commission and to bring it up in front of this board and discuss it to the extent that you want to discuss it and make a decision that it's acceptable to you or not. Thank you.
Thank you.
Janie Anderson.
Okay.
Challenged.
I think he manhandled it a little bit there.
There.
No, it's not that. You have to bring the whole thing down, not the...
Yeah, now it's on. Cool. Anderson, 11th Place and 119th Street. Ironically, the case that Rox brought up is the only code case that I've been given so far as part of my public records request to see if there was any substance to the continuing accusations that Tracy and Christian make about the now former code board. Well, not only were there mistakes made at the at staffing level, even some of the attorney comments were patently incorrect. He may have misunderstood or misconstrued something he heard on the tape, because according to his notes, he only had the tape, didn't have the agenda back up. Now, the fair and professional thing to have done in that case would have been to get us all involved so that we could clarify any issues, but of course that didn't happen. And so you're left with the feeling that that just didn't fit with the narrative some were trying to create here. And clearly Tracy and Christian had a responsibility that...
Your mic.
Yeah, this is not working. Let's try this again. There, much better for short people.
Please reset the clock for another minute,
Well, not
please.
reset, but you got to go back a little. Clearly, if there were substantive issues, there should have been special meetings with the attorney present where we hash things out, where we come to some sort of resolution. And the fact that that didn't happen, I'm left with the feeling that these are all more fantasy than they are reality. And in terms of the accusation that some were too punitive, with the number of cases we heard that were life safety, construction without a permit, properties that had multiple serious violations on them, violations that were more than a year old. Well, I'm not inclined to support long compliance times or $25 fines. So yes, I would push for things that actually had some substance to them. But the sad part is, I know if you put another board together, you will manage somehow to find people who are willing to lower standards and who are willing to be kinder and gentler to those breaking our laws, and that's really unfortunate for the entire community. A big concern about the special election, not even qualifying for 3 weeks. Now, I understand we've got to advertise, but surely we can start qualifying ahead of that advertising. It's going to be tough enough through all the holidays for residents to get to know whomever chooses to run, and it's bad enough that we even have to do this. Let's not make it worse by shortening the time we have to vet these candidates.
Thank you. Next.
Barbecue.
Barbara Kuehl, 111th Street. I completely agree with Mac Kennedy about his assessment of Jenny Sardella, and also Dan Keyes. Mac was asking Jenny to resign, and Dan was saying that you need to ask her. This is your responsibility as a commissioner. It's in the charter. It says 3 meetings missed, and as far as I'm concerned, and I said this a long time ago, and many times, you should have been asking any time a commissioner misses a meeting, you should be asking why. Because residents want to know. I want to know if she's on vacation or somebody decided they just don't feel like coming. This is what we base our votes on. And the charter says you are supposed to find out why she's missed the meetings and then act on it. And like everybody said, we all heard that Jenny's had problems. Fine, nobody's faulting her for that. But if she isn't addressing this properly by resigning, if she can't fulfill her duties, which she's being paid for, then you need to force the issue. And this isn't being mean. This is what commissioners are that you're being paid to do. You were elected to protect the residents, not have. You may like to have 3 on the commission at a time because it cuts down on problems. But get up to the plate and make a decision now that you have an election coming up. As far listening to the last discussion about the code board, it's, first of all, I go to all the code board meetings, so I know none of you have been there. And listening to the conversation from the attorney, even from the manager, it's apparent that it wasn't, the code board process wasn't even discussed. For the attorney to say, do you sometimes have problems with repeat violations? I mean, seriously, anybody that was familiar with any of the meetings would see that that's an ongoing problem. And for you to make a decision on whether or not to go forward with a code, to go to a special magistrate without thoroughly investigating how the board runs, the issues that it deals with, you have no business, or you have no knowledge to even be able to make these decisions. You're so ignorant about the process. I can't even believe it, because you haven't taken the time to even ask the questions. You're asking questions that are so novice that honestly, I'm amazed. And you, again, you should be ashamed to decide to change something that has worked without issue to something in the unknown that's going to cost us money just because you didn't want it. And if you don't agree with that, tell us, good, tell us why you wanted to change this.
Thank you. Next.
Chuck Roth.
Chuck Ross, 11166 Griffin Boulevard. Basically, Mac and Dan and Janie and Barbara pretty covered just about anything I could possibly say, except to reinforce. You have a duty, as Dan said, you have a duty to have a discussion and find out why Jenny has missed 4 out of 10 regular commission meetings, plus at least 2 special meetings I can think of off the top of my head, maybe 3. She's not doing her duty for whatever reason. The fact of the matter is, you guys need to have the discussion and to ask her to resign. Or you have the power to remove her, which is what you should do. I actually have a question. Has she ever put in a resignation letter and withdrawn it? It's a public records request.
I'll answer that as a no.
Okay. Thank you.
Gary Q.
I want to thank you for a very entertaining and amusing discussion of the ordinance. I mean, it is, I'm just flabbergasted. I mean, you never come to board meetings, you have no idea about the ordinances, you discuss things. The village manager who sat in the board meetings, who is in charge of code, listening to you and isn't correcting you as you go. Now let's start. How do we start a meeting? One of the first things we do is we swear everybody in who's going to speak. You can't just grab, Dan or Mac or somebody else and have them present a case. They're a witness. You're looking for a witness to the case. And somebody that sits in the office who's available that day is not a witness to the case. I don't know how many of you even understand the difference between a citation and a notice of violation. 2 completely different things. Citations were developed specifically for recurring minor things. You don't want to cite, as far as life safety, health, construction issues, you have an ordinance which covers those things. And even with the citations, you're not obligated to give a citation. You can elevate it to a notice of violation. The code compliance officer has that authority. You have a noise ordinance. Okay, it isn't limited to a $25 fine. Okay, and it's an escalating process. It goes to $50 and $75 as it repeats. I don't know where you are in delegating stuff to your code compliance board. I don't think you know enough to even decide. Believe me, you don't. You say cases under $5,000. Well, 90% of our cases are under $5,000. Most of our cases are routine. I mean, whenever we wanted legal assistance, we asked for it. In fact, the one time I didn't get it. I talk about risk. What's the analysis here? How many cases have we had? How many have gone to the circuit court? How many legal cases have we had? How many settlements have we had? I mean, let's look at the history. The basis on a non-event is ludicrous. It just irks me that you even make statements like that. And you don't even seem to understand the process, nor does your attorney tell you, who doesn't seem to understand any of this. If somebody contests a violation, they don't sue. They go to circuit court. Okay? They don't come in and sue you. They can't. It's against the law. And then you maybe you'll have the legally Jesus, that went quick. Anyway, I only had about 6 other items that you're like,
No one else.
No one else. Anybody else want to talk? Okay. Public comments are closed on this.
No, I think there's one more.
Dr. Jonas, do you want to talk? You're welcome to go ahead and come up. Public comments are closed. We'll move on to Resolution 2019-26 special election. I'll have the attorney read.
A resolution of the Village Commission of the Village of Biscayne Park, Florida, calling a special election to fill vacancy of one commission seat, scheduling special election to be held on Tuesday, January 7th, 2020, providing for notice of special election, providing for candidate qualifying, providing for special election polling location, providing for severability, providing for an effective date.
Open for discussion. Start with Commissioner Tudor.
This one is actually pretty straightforward. I guess one question is, we have down the date of first publication, November 12th. What triggered?
So the statute requires that the village publish a notice of special election at least twice. I think we're actually going to do a third one even earlier to put people on notice. But we went backwards from the date once the Miami-Dade County Supervisor of Elections provided us with a tentative date to present to the Commission for approval. So once we had the tentative date of January 7th from the County Supervisor of Elections, we went backwards to make sure we would comply with the statute. It's section, if you look on page 205, whereas section 100.342 Florida statutes requires the village to publish a notice of special election in a newspaper of general publication within the village at least twice, once in the 5th week and once in the 3rd week prior to the week in which the election. So we did the backwards math once the Supervisor of Elections gave us a tentative date for the Commission to approve.
Okay. I asked that because one of the comments from public comments was about the qualifying period of November 13th, and so I just wanted to get to the fact that November 13th you can't have a qualifying period until you actually have the publication.
The clerk and I think we've been on the phone and emails with the Supervisor of Elections all week trying to get the date because there's a lot happening with the county during our window to have this special election, so getting the date was tough. But do
you want to elaborate on that just so people know?
Okay, so there's a lot of things happening with the county to get ready for the 2020 election with respect to security for polling places and everything, with all the allegations that were the presidential election. So the county has really finite resources to accommodate a special election with such a frame. But within our 90 days, couple that with our 90 days are running through holidays.
Just one moment, please.
Yeah.
Getting a date certain approved was, thank you. Oh, hello? Okay. So that process limited the availability that the Supervisor of Elections had to accommodate a special election of Biscayne Park, because upgrading that technology was already scheduled. So we had to work around that, and we also had to work around the Thanksgiving holiday and the holidays in December and New Year's. So that's how we got the date from the supervisor of elections, and that's why there was a lot of back and forth about that with the county.
I know I spoke to the city manager about that. Do we have documentation that says Dade County says that the qualification period has to start after the advertising? If it doesn't, there's no reason why the qualification period should be November 13th to the 22nd. Unless, and that's what I asked.
The clerk did speak with the county today. Madam Clerk, you want to expand on that?
Yes, I spoke with two persons on the Department of Elections, and one is specialized in qualifying candidates for the county, and the practice is to start the qualification after the notice, public notice.
So, any other questions? With that, is there...
So you're saying that the Herald can't come up with a sooner date, or do we have to do it in the Herald? Can it be advertised in another newspaper? Because by having the qualification be from the 13th to the 22nd, that means people are not going to start campaigning to the 23rd. Even with before, we didn't have enough time for campaigning. You're now going to have it from the 23rd to January 5th. You got Christmas, you got Thanksgiving, and you got all those holidays. You're just not going to have enough. I mean, low turnout was going to be low turnout. This is really going to be really bad low turnout.
It seems to me the statute is kind of unfortunately dictating a lot of this, as well as the supervisor elections. I don't disagree with what you're saying. I just don't, unfortunately, I don't think there's...
I asked the clerk and I asked the city manager. I wanted to see the statute and to present to me the statute, not with the person in the office. I want to see the actual statute that says you cannot, because we've been doing this for I don't know how many years. Again, everybody says, well, the past is wrong. I don't believe the past has been wrong. The last clerk we had, Maria, this was done, we had qualifications done within a certain period of time. We have never had where we had to wait 3 or 4 weeks before we even have qualifications. I want to see a statute that says that actually, that you can't do it unless you have advertising.
You can talk to the attorney about that. I'm not going to...
I find it hard to believe.
Yeah, no one's discussed this with me, so I don't understand what your question is. First, I want to clarify something you said. The dates that the publication has to run isn't because of what the Herald can do. We have to work backwards off of the election date we're given.
If I'm correct, it says that 45 days, our election is to be held within 45 days of that, at the maximum 90 days. That's what
You're right about that. Yes,
okay.
That's right.
So you don't have to, by going backwards, you should be going forward to as long as we meet the qualification from the beginning of when we do it, from the 16th all the way to as long as we qualify 30 days from the beginning of the 16th to that, you're going backwards. That's where you're supposed to be going.
The Department of Elections, the Supervisor of Elections, gave us the date of January 7th.
Right.
Okay? From there, we have to work back, because there's dates that we have to publish, and so we have to publish twice between then and the beginning. And it's also a matter of time to put it together, which is, the clerk is doing.
Right, but if you have again, I asked for the statute that says that the advertisement has to say that the qualification period. If it doesn't, you can still have what I was going to suggest tonight was to have the qualification period from October 28th to November 10th. Then you could still do your advertisement on the 12th or the 13th.
So
my question is, does it say...
I'm sorry, the clerk, just a second, because I want him to finish his thought, and I don't want interruptions. So finish your thought,
Sure.
Vice Mayor, and then I'd like the clerk and the attorney both to just...
The question I asked, and I asked the city manager and clerk, if it says in the advertisement that you have to you can't do the advertisement unless you do the qualification period first. There's no reason why you can't do the qualification from October 28th to the 10th and then still do your advertising. I'm not questioning the advertising when it's supposed to be done, all of that. The question I'm at is the qualification period.
And the clerk asked the Supervisor of Elections that day, or two people at the Department of Elections that day.
Yeah. Right.
And their response was consistently that the qualification period begins after the first ad runs.
You have to
And to
advertise
be-
it first, or people,
And with respect
On
to...
that
with
first publication?
No, let me finish,
Okay.
please. With respect to your proposed date of October 28th, this is a tentative date that we've received from the Supervisor of Elections to present to the Commission for approval. It's Thursday night.
This is not, this is,
We then have to, the clerk and I then have to go back to the County Supervisor of Elections and say, here, look, the Commission's good with this date. What's next? And then there's a process with the Supervisor of Elections to finalize this date. It's not done here.
right.
This is a step.
But the last special commission meeting, the last special election that we had, and I was part of that, was the commission decided when we were going to have a special election. We didn't wait 3 weeks, 4 weeks before we had the qualifying. Look at it. It wasn't done. It was done right away within a certain time period.
No.
Qualification
Hold on.
was.
I'm sorry, hold on, please.
By the documents that I have on file, you have to wait almost 3 weeks because the notice was done prior to the qualification. I have on file all the documentation that went through the
Right.
special election in 2017 and prior of that.
So, to go back to this, then, I just want to be clear for the residents, so we're transparent, that the village manager, village attorney, and the clerk work with Miami-Dade County of Elections to come up with the resolution to propose a date that we can accept. We are this evening only voting on that date of January 7th, correct?
And then the advertising
And then the
dates
advertising
to
dates as
comply
well,
with the
to comply with the statute.
Because
Okay.
our advertising dates are mandated based on...
The backup, I got it.
Right.
Got it. Commissioner Chu, do you have anything you want to add? Because I'm fine, not because I'm fine with it, I'm not fine. I agree with you, having you and I both know what campaigning is like, all three of us sitting up here do. Let me finish what I'm saying, please, if I may. Thank you. I don't disagree with your intention of trying to give people more time to campaign, because I understand the need for that. At the same time, you have to follow the law and what the county says. So for that reason, I'm not happy with it, but I don't think we have an option going forward. I just don't. And then, if I may, go ahead, Vice Mayor.
What you said, tonight we're having a resolution that has to do with the date, the 7th. I agree 100% that. With the advertisement, I agree with that 100%. You're saying that we're not voting whether or not with the qualification period.
No, I'm telling you we are, because at the end of the day, that qualification period's in here, correct?
Once the commission votes on this, the clerk and I have a lot of work to do in a very short period of time with the Supervisor of Elections. So there's not going to be, we're not breaking this up, so we have to keep checking back in with the commission to do our jobs and make sure this special election goes off the way it's supposed to. Once we have this resolution, we're following up with the Supervisor of Elections to make sure everything's on track for January 7th.
The one that you sent originally for the 14th, that we had originally on for January 14th, it said date of qualification, special election, and location of where it's at. So we can decide when the qualification period is, as long as we put that in the resolution, correct?
Not-
You're saying...
Hold
Not
on,
only
hold on.
that,
You
the
asked a
notice-
question the clerk would like to answer, if I may, Madam Clerk.
Not only the qualification period, we have to, the dates have to match with the notice. That's the most important notice, the first notice.
Yes.
After that, everything starts rolling.
Right. So if we put the qualification period at the time that I'm talking about, that'd be in the notice. I'm confused on that.
Because then you're asking, because, see if I'm understanding correct, I just want to make sure I'm understanding. You're trying to have the qualification period before the notice, and that is the problem. You can't
Right.
do it in that order, it has to
And
be
we
the
can't do it.
reverse.
What, I think part of the issue also, I think that the Vice Mayor mentioned was he wanted a longer, a longer qualifying period as well.
No, it's just August 28th to the 3rd to the 10th. Well, I originally had it to 28th, from the Monday to 28th to the Monday of November 4th. I had it as the November.
That's a longer qualifying period. And the problem with that is he's asking to do it before the ad occurs, which you can't do.
But we can't, and we can't definitely run this ad until the Supervisor of Elections completely ratifies this date. What we have right now is the proposed date that the supervisor election says they can accommodate the village to give us the polling equipment and all of that to run the special election. That's the date that is a potential date that the supervisor elections can work with us to get this done on that date. It's not locked in until we go back to the supervisor of elections for the county
With the resolution.
with a resolution from the commission that the village is good with that date. From there, we finalize the process with the supervisor elections to lock in the date. It's not locked in right now. That's the procedure.
Okay, so with that in mind, unless there's further discussion, is there a motion to approve resolution?
Well, I just have one question.
Sure,
I
sorry,
think.
go ahead.
One of the things I was hearing, one of the things I'm hearing or there's concern is that the qualifying period may be a little shortened during the special election. Typically, we usually have 14 days as the qualifying period. So if we're being told by the county that we can't move it before the first publication date, then could we not just extend, instead of having the qualifying period end on the 22nd, end it further out?
No, because then you're taking away from the campaign. Because you can't campaign until you qualify, which is the qualification.
Close for
qualification. So if you extend it out.
One person at a time, please.
I'm sorry.
No, you go ahead, you have the floor,
If
sir.
you extend it out, let's say you extend it to the 28th, then you can't campaign until the 28th.
And that's
you're
Thanksgiving
already-
week.
That's going to be I mean, this
Right.
special election is already going to be a problem with tightness that it is, especially when my ones that I'm doing a qualification early, is that they qualify and then they can do campaign right away as soon as they qualify. Well,
Excuse me.
yeah, it's, unless you're telling me that it says, unless you're telling me that Dade County has it in writing that says, for sure, you cannot have a qualifying period until the first advertising, which I still haven't gotten that answer, the first advertising, then there is no reason why we can't have, again, the 7th I have no problem with, and I have no problem with the advertising dates. My problem that I'm having is the qualifying period.
Can I ask,
If there's a Dade County that actually says in writing that you can't do that, you have to advertise first before you can qualify, then I have no problem with that. But if it doesn't say that you have to you have to advertise first before you can put in your qualified notices, then there's no reason why we can't switch.
I think the clerk's answered that twice now, and respectfully, sir, but I do think, my question is, we can't post, and this was the big issue, and I just want to be clear. I know you tried to get a later date so that we would have it, that wasn't available with them, correct?
The problem with later dates, we also have requirements to get the ballots finalized and approved by the supervisor of election. That's something behind the scenes that takes place before the election. So the qualifying period has to end to give us sufficient time to make sure that the ballot is compliant when we submit it to the county supervisor of elections. So pushing this further out, I mean, Charter Review Advisory Board, if you're listening, this isn't the greatest part of the charter. We should revisit it because this is a scramble. Since this 90 days, is over a couple of holidays, there's really not a lot of time. And it's not ideal, I agree with all of you on that, but we can't push it further back because we cannot scramble to put the ballot together
violating the charter.
and risk that it's not compliant or kicked back by the
violating the
supervisor of elections. There's not going to be time to really amend it. I mean, again, we're talking about Miami-Dade County, one of the biggest counties in the country. There isn't a really quick turnaround. And again, with respect to the November 13th qualification period beginning, again, we have to wait for the county to finalize approving this date for us. It is October 24th. I mean, we may not get formal approval paperwork much sooner than the November 13th date from the county. They're very busy. We've been communicating with the county supervisor of elections all week because they are completely immersed in preparing for the 2020 presidential election and the security issues with that. So,
unless Commissioner Tudor has any further comments, I think it's been asked and answered. I think at this point we need a motion because we have got to get somebody elected here and not violate the charter.
Yeah, the last thing I'm going to say is that the issue regarding whether or not you can have a qualified period before the publication date has been answered by the manager and by the clerk, that they have spoke to the county. They're on the record that they have spoke to the county, and this is the information that was provided by the county. It may be good just to get something from the county at some later date in writing, but just to have that. But it is on the record here that that we can't have the qualifying period before that first publication date. And then I mentioned about, the reason why I mentioned about moving, that we usually have 14 days and moving the end of the qualifying period, you would have to move it out, but you're moving it out, and all of a sudden now you're getting into the Thanksgiving holiday period. So, you know, this is what happens when a situation like this arises and you have to have a special election. I personally don't want to talk to the county and try to move the election date out further because we need to get somebody elected and up here. So, yeah, it's unfortunately, I think we're kind of in between a rock and a hard place.
Agreed.
One quick comment too, and this is just moving on. Our January commission meeting would be on January 7th, which is the night of the special election. So we're going to need to move our commission meeting to the 14th. And that way we can also, by that point, we should have the certified results from the commission. So
You may or you may not,
we may or may not.
but definitely shouldn't be on the same night as the election.
Well,
No, but
Well, the
same night,
installation's
but
not till
the
February.
official.
But it's not, hold on one second. I think before we discuss even moving it, why don't we hear back from the county and make sure that's the date, because it could change.
okay.
No, and you said it was, no, she's saying that February 4th is the installation. No, it's not. City manager, didn't we discuss that you changed that?
Well, that's what I'm bringing up now is we can discuss that. And so.
Okay.
I'm sorry.
10 days.
To be respectful, Commissioner Samaria, everything has to be done up here. It can't be done in
Yeah,
people's
it can't
offices
be-
regarding them moving time.
What was moved? I'm sorry, because no one...
He's claiming something was moved, and I'm a little
What was
concerned about
No,
that.
nothing's.
Our charter says that the person we just had this discussion about people not being sworn in when they were supposed to be sworn in. Our charter says that after the person is certified and is in, has to be sworn in 10 days. This is more than 10 days. This is February 4th. The election is over. Let's say we get the results, which most of the time with our special election, we're going to get the results. Usually we can find out the same day we won, unless there's an absentee ballot. Let's say if a vote is 200 different and there's 300 outstanding ballots, that's going to be a different. We most of the time will have our results that evening. We know the person's going to is elected. And then, of course, it has to be certified by the county.
And
But-
that's the thing, and that's why we waited last time, it was a regular election, we needed that certification.
Right.
This being a special election, I think that we'll probably get the certification in under the 10 days that we did last time. This should be, a matter of.
Which is why you're suggesting the 14th, if the
And that's
7th,
why-
but only
yeah.
if the 7th. That's why I'm saying we're premature here. We should wait until we get back from the county what the date is, and then we can talk about rescheduling the meeting to make the 10-day.
Agreed.
Do you agree with that, Vice Mayor?
No, this is within the 10-day period.
Yep.
That's what our charter says.
Okay. With that, is there a motion to approve Resolution 2019-26?
I make a motion to approve resolution number 2019-26.
Is there a second? I'll second the motion. All those in favor?
Aye.
Aye. All those opposed? Motion passes 3-0.
I'm sorry, Vice Mayor? You said no?
We don't have a choice. We have to have a special election, so I have to go. I still don't believe the date on that you have the qualification period, but
Okay, is there a motion to adjourn this meeting?
I make a motion to adjourn this meeting.
All those in favor? I'm sorry, second. All those in favor? Aye. Okay, motion's adjourned. We're having a workshop following this on branding. We're going to take a 5-minute recess. Thank you.